Part 3. Section 120. Dishonest appropriation. 1. An appropriation of a thing is dishonest. A. If it is made with an intent to defraud, or B. If it is made by a person without a claim of right, and with the knowledge or belief that the appropriation is without the consent of a person for whom that person is trustee or who is owner of the thing, or that the appropriation would, if known to the other person, be without the consent of the other person. 2. It is not necessary, in order to constitute a dishonest appropriation of a thing, that the accused person should know who the owner of the thing is, but it suffices if the accused person has reason to know or believe that any other person, whether certain or uncertain, is interested in or entitled to that thing, whether as owner in that person's right or by operation of law, or in any other manner, and a person so interested in or entitled to a thing is an owner of that thing for the purposes of the provisions of this Act relating to criminal misappropriations and frauds. 3. The general provisions of Part 1 with respect to consent, and with respect to the avoidance of consent by force, duress, incapacity, and otherwise, apply for the purposes of this section, except as is otherwise provided in this chapter with respect to deceit. Section 122. Acts which amount to an appropriation. 1. An appropriation of a thing by a trustee means a dealing with the thing by the trustee, with the intent of depriving a beneficiary of the benefit of the right or interest in the thing, or in its value or proceeds, or a part of that thing. 2. An appropriation of a thing in any other case means any moving, taking, obtaining, carrying away, or dealing with a thing, with the intent that a person may be deprived of the benefit of the ownership of that thing, or of the benefit of the right or interest in the thing, or in its value or proceeds, or part of that thing. 3. An intent to deprive can be constituted by an intent to appropriate the thing temporarily or for a particular use, if the intent is so to use or deal with the thing that it probably will be destroyed, or become useless or greatly injured or depreciated, or to restore it to the owner only by way of sale or exchange, or for reward, or in substitution for another thing to which that owner is otherwise entitled, or if it is pledged or pawned. 4. It is immaterial whether the act by which a thing is taken, obtained, or dealt with A. is or is not a trespass or a conversion. B. is or is not in any manner unlawful other than by reason of its being done with the purpose of dishonest appropriation. And it is immaterial whether, before or at the time of doing the act, the accused person had or did not have possession, custody, or control of the thing. Section 123. Subject matter of stealing. 1. The criminal offense of stealing, fraudulent breach of trust, robbery, extortion, or defrauding by false pretense can be committed in respect of a thing. A. B. C. D. Whether living or dead, and whether fixed to the soil or to a building or fixture, or not so fixed, and whether the thing is a mineral or water, gas, or electricity, or of any other nature, and whether the value of the thing is intrinsic or for the purpose of evidence, or is of value only for a particular purpose or to a particular person, and whether the value of the thing does or does not amount to the value of the lowest denomination of coin. 2. For the purposes of subsection 1, a document is of value, whether it is complete or incomplete, and whether or not it is satisfied, exhausted, or cancelled. 3. In proceedings in respect of a criminal offense mentioned in subsection 1, it is not necessary to prove ownership or value. Section 124. Stealing. 1. A person who steals commits a second-degree felony. 2. Where the court which finds a person guilty of stealing is satisfied that on not less than 2 previous occasions the accused was found guilty of stealing, the court shall order that the whole or a part of a term of imprisonment imposed by it shall be spent in productive hard labor. 3. A person in respect of whom the court makes an order under subsection 2 is disqualified for election to Parliament or to a district assembly within the meaning of the Local Government Act, 1993. Act 462, for a period not exceeding 5 years. 4. For the purposes of this section. Productive hard labor means labor in a state farm or state factory or any other public, cooperative or collective enterprise specified by the minister. Previous occasions referred to in subsection 2 may include occasions which occurred prior to the commencement of this act. Section 125. Definition of stealing. A person steals who dishonestly appropriates a thing of which that person is not the owner. Section 126. Consent by wife in case of stealing. 1. Where it is proved, on behalf of a person accused of having stolen a thing, that the wife of the owner of the thing consented to its appropriation by the accused person shall not be convicted unless it is proved against the accused person that the accused person had noticed that the wife did not have the authority to consent to the appropriation. 2. Where it appears that the accused person had committed, or designed to commit, adultery with the wife, the accused person shall be deemed to have had notice, but shall not in that case be deemed to have committed the criminal offense of stealing by reason only a. b. of the appropriation, with the consent of the wife, or of the assistance to the wife to appropriate a wearing apparel of the wife or money or any other thing of which the wife is apparently permitted to have the disposal for her own use. Section 127. Stealing of thing found. A person who appropriates a thing which appears to have been lost by another person has not committed the criminal offense of stealing it unless a. at the time of appropriating it, that person knows the owner of the thing or by whom it has been lost, or b. the character or situation of the thing, the marks on it, or any other circumstances indicate the owner of the thing or the person by whom it has been lost, or c. the character or situation of the thing, the marks on it, or any other circumstances indicate that the person who has lost the thing appears likely to be able to recover it by reasonable search and inquiry, if it were not removed or concealed by any other person. Section 131. Defrauding by false pretense. 1. A person who defrauds any other person by a false pretense commits a second-degree felony. 2. A person who by means of a false pretense or by personation obtains or attempts to obtain the consent of another person to part with or transfer the ownership of a thing by a false representation of acting in accordance with the instructions, orders, or a request of the President or member of the Cabinet, commits a second-degree felony under subsection 1, and is liable to a term of imprisonment of not less than 10 years and not more than 25 years despite Section 296 of the Criminal and Other Offences, Procedure Act, 1960, Act 30. Section 132. Definition of defrauding by false pretense. A person defrauds by false pretenses if, by means of a false pretense, or by personation that person obtains the consent of another person to part with or transfer the ownership of a thing. Section 133. Definition of, and provisions relating to, a false pretense. 1. A false pretense is a representation of the existence of a state of facts made by a person, with the knowledge that the representation is false or without the belief that it is true, and made with an intent to defraud. 2. For the purposes of subsection 1. A representation may be made by written or spoken words, or by personation, or by any other conduct, sign, or means of any kind. B. The expression, a representation of the existence of a state of facts, includes a representation as to the non-existence of a thing or a condition of things, and a representation of any right, liability, authority, ability, dignity or ground or credit or confidence as resulting from an alleged past fact or state of facts, but does not include a mere representation of an intention or a state of mind in the person making the representation, nor a mere representation or promise that anything will happen or will be done, or is likely to happen or to be done. C. A consent is not obtained by a false representation as to the quality or value of a thing, unless the thing is substantially worthless for the purpose for which it is represented to be fit, or to have been substantially a different thing from that which it is represented to be, and d. Subject to paragraphs A, B, and C, if the consent of a person is in fact obtained by a false pretense, it is immaterial that the pretense is of a kind that would not have an effect on the mind of a person using ordinary care and judgment. Section 134. Personation. 1. Personation means a false pretense or representation by a person that that person is a different person, whether that different person is living or dead or is a fictitious person. 2. A person may commit the criminal offense of personation although that person gives or uses that person's own name, if that is done with intent of being believed to be a different person of the same or of a similar name. Section 135. Fictitious trading. Where a person orders, or makes a bargain for the purchase of goods or things by way of sale or exchange, and after obtaining the goods or the things, that person defaults in payment of the purchase money or in rendering the goods or things to be rendered by that person by way of an exchange, that person commits the criminal offense of defrauding or attempting to defraud by false pretenses if a. b. At the time of giving the order or making the bargain, that person intended to make that default, and the order was given or the bargain was made with intent to defraud and not in the course of a trade carried on in good faith. Section 136. Distinction between stealing and false pretenses. 1. Where the owner of a thing, or a person having authority to part with the ownership of that thing, gives consent to the appropriation of it by the accused person, then, although the consent has been obtained by deceit, the accused person shall not be convicted of having stolen the thing, but may be convicted of the criminal offense of having defrauded by false pretenses, if the acts amounted to the criminal offense. 2. The consent to be proved by the accused person for the purposes of subsection 1 is an unconditional consent to the immediate and final appropriation of the thing by the accused person, by way of gift or barter, or of sale on credit to the accused person. Section 137. Charlatanic advertisements in newspapers. 1. The publication in a journal or newspaper of an advertisement or a notice relating to fortune-telling, palmistry, astrology, or the use of any subtle craft, means or device, by which it is sought to deceive or impose on a member of the public, or which is calculated or is likely to deceive or impose on a member of the public, is illegal. 2. The editor, publisher, proprietor, and the printer of a journal or newspaper in which the advertisement or notice is published commits a criminal offense and is liable to a fine not exceeding 25 penalty units. Section 140. Falsification of accounts. 1. A clerk, a servant, or a public officer, or an officer of a partnership, company, or corporation commits a second-degree felony who does any of the acts mentioned in paragraph A or B with intent to cause or enable a person to be defrauded, or with intent to commit or to facilitate the commission, personally or by any other person, of a criminal offense. A. B. Conceals, injures, alters, or falsifies a book, or an account kept by or belonging or entrusted to the employers or to the partnership, company, or corporation, or entrusted to the officer, or to which the officer has access, as an officer, or omits to make a full and true entry in an account of anything which the officer is bound to enter in the account, or publishes an account, a statement, or prospectus, relating to the affairs of the partnership, company or corporation, which the officer knows to be false in a material particular. Point 40. 2. For the purposes of subsection 1, officer means a clerk, a servant, a public officer or an officer of a partnership, company, or corporation. Section 146. Dishonestly receiving property. A person who dishonestly receives property which that person knows has been obtained or appropriated by a criminal offense punishable under this chapter, commits a criminal offense and is liable to the same punishment as if that person had committed that criminal offense. Section 147. Dishonestly receiving. 1. A person commits the criminal offense of dishonestly receiving property which that person knows to have been obtained or appropriated by a criminal offense, if that person receives, buys, or assists in the disposal of the property otherwise than with the purpose to restore it to the owner. 2. It is immaterial whether the criminal offense by which the property was obtained or appropriated was or was not committed within the jurisdiction of the court. 3. Where the property was obtained or appropriated beyond the jurisdiction of the court by an act, the doing of which within the jurisdiction would be a criminal offense punishable under this act. The act is, for the purposes of this section, equivalent to a criminal offense punishable under this act. Section 148. Possession of stolen property. 1. Where a person charged with dishonestly receiving is proved to have had in possession or under control anything which is reasonably suspected of having been stolen or unlawfully obtained, and that person does not give an account, to the satisfaction of the court, as to the possession or control. The court may presume that the thing has been stolen or unlawfully obtained, and that person may be convicted of dishonestly receiving in the absence of evidence to the contrary. 2. The possession or control of a carrier, an agent, or a servant is, for the purposes of subsection 1, possession or control of the person who employed the carrier, agent, or servant, and that person is liable accordingly. Section 149. Robbery. A person who commits robbery commits a first-degree felony. Section 150. Definition of robbery. A person who steals a thing commits robbery. A. If in, and for the purpose of stealing the thing, that person uses force or causes harm to any other person, or B. If that person uses a threat or criminal assault or harm to any other person, with intent to prevent or overcome the resistance of the other person to the stealing of the thing. Section 151. Extortion. 1. A person who extorts property from any other person by means of threat commits a second-degree felony. 2. When used with reference to extortion, threat does not include a threat of criminal assault or harm to the person threatened. Section 152. Unlawful entry. A person who unlawfully enters a building with the intention of committing a criminal offense in the building commits a second-degree felony. Section 153. Explanation as to unlawful entry. A person unlawfully enters a building if that person enters otherwise than in the exercise of a lawful right, or by the consent of any other person able to give the consent for the purposes for which that person enters. Section 157. Trespass. A person who A. unlawfully enters in an insulting, annoying or threatening manner on land belonging to or in the possession of any other person, or B. unlawfully enters on land after having been forbidden so to do, or C. unlawfully enters and remains on land after having been required to depart from that land, or D. having lawfully entered on a land, acts in a manner that is insulting, annoying or threatening, or E. having lawfully entered on a land, remains on that land after having been lawfully required to depart from that land, commits a criminal offense and is liable, on the complaint of the owner or occupier of the land, to a fine not exceeding 25 penalty units, and the court may order the removal from the land, by force if necessary, of a person, an animal, a structure or a thing. Section 158. Forgery of judicial or official document. A person who, with intent to deceive any other person, forges a judicial or an official document, commits a second-degree felony. Section 159. Forgery of other documents. A person commits a misdemeanor who forges a document. A. with intent to defraud or injure another person, or B. with intent to evade the requirements of the law, or C. with intent to commit, or to facilitate the commission of, a criminal offense. Section 172. Causing unlawful damage. 1. A person who intentionally and unlawfully causes damage to property. A. to a value not exceeding 1 million cedis or without a pecuniary value, commits a misdemeanor. B. to a value exceeding 1 million cedis commits a second-degree felony. 2. A person who intentionally and unlawfully causes damage to property in a manner which causes is likely to cause danger to life commits a first-degree felony. 3. For the purposes of this section, property means movable or immovable property. Section 173. Definition of damage. For the purposes of this act, damage includes not only damage to the matter of a thing, but also an interruption in the use of that thing, or an interference with that thing by which the thing becomes permanently or temporarily useless, or by which expense is rendered necessary in order to render the thing fit for the purposes for which it was used or maintained. Section 174. Explanation of unlawful damage. 1. A person does an act or causes an event unlawfully, within the meaning of the provisions of this act relating to unlawful damage, where that person is liable to a civil action or proceeding, or to a fine or any other punishment under an enactment. A. In respect of the doing of the act causing an event, or B. In respect of the consequences of the act or event, or C. In which that person would be so liable if that person caused the event directly by a personal act, or D. In which that person is liable to be restrained by injunction or any other proceeding from doing that act or causing that event. 2. It is immaterial whether a person accused of a criminal offense in respect of any premises or a thing is or is not in possession or occupation of the premises or of that thing. 3. A person who is interested jointly or in common with other persons in any premises or a thing as an owner or otherwise, or who as owner is a trustee for any other person, can commit a criminal offense, punishable under the provisions referred to in subsection 1, by an act which is unlawful under this chapter. 4. A person who is the sole beneficial owner of any premises or a thing can commit a criminal offense punishable under the provisions referred to in subsection 1, by an act done with intent to injure or defraud a person or to cause harm to a person although the act is not otherwise unlawful. 5. Despite anything contained in Part 1 as to mistake of law, a person is not liable to punishment in respect of doing a thing which that person in good faith believes to be entitled to do,